All right, I'll go along with what probation is now recommending, but I'm gonna let you know. Um, Ms. Polera gives people a chance that's consistent with how this court feels. If you mess this up, I'm not going to be because the final decision is mine. I'm not going to at all be listening to any kind of break for it. You will just do time.
Good morning, Mayor. Please, the court attorney Damian Cash, P number 85852 on behalf of Mr. Taylor Byer. Mr. Byer, state your name for the record.
Taylor Martin Byer, Your Honor.
All right, date and time for sentencing. Have you reviewed the report?
Your Honor, yes, we've reviewed the PSI report. I have no additions or changes or deletions, Your Honor. I just do at some point want to discuss the bond violation that Mr. Byer had in the report that I recently received.
Well, go ahead.
So, Mr. Byer, I called records at Bear River Treatment Facility in around about Traverse City area. He was admitted for treatment on November 24th. That is the reasons and the explanation for why he was not able to test. I do understand that he was in contact with, at times, the probation department to inform them that he was in treatment. I'm not exactly sure how those conversations detailed. However, he was in treatment. He completed December 23rd, and they confirmed the records to me this morning, and I also reported those records to your court as well, Your Honor.
He completed Bear River.
He completed Bear River, yes, Your Honor.
I think I'm not going to find a violation because I think that the issue is potentially that there wasn't a release information. It wasn't anything that this gentleman did. I was a circumstance where information was just not flowing
Back and forth.
yes, like it should have been. So I'm not going to find a violation of that.
Thank you, Your Honor.
Doesn't seem to be a violation. He's in treatment. So, all right.
He owed him some flowers and candy as I promised him this morning for this record.
Okay. Okay. Anything else?
Other than I'll just briefly allocute. I've been in contact with his family, his brother, and they informed me along his siblings. They are, I would say, very interested in seeing his growth and his continued development as he continues to go through treatment. I believe it is very serious to him, as well as he's admitted to himself. He's explained to me multiple times that it is very serious to him to get through this treatment process to better himself, and that really he just want to get back to being a productive citizen and back to work, Your Honor.
Yes, Your Honor.
Sir, anything you want to tell me?
I want to say thank you for everything you did, because it actually helped me in my life to get my life on track. And I only want to do the right thing. I want to be the best dad I can be for my son. And I just want to be the best person I can be. And I just want to say thank you for helping me with my journey, because I'm on the right path. And I just want to say thank you.
You're welcome, sir.
Thank you.
Ms. Blair, just so that I can make sure I'm understanding this, the proof of treatment.
Your Honor, I was not able to
Fair.
obtain that information because there was no release of information.
Got it.
However, it was brought to my attention when Mr. Byer was arraigned that he advised the court that he was in treatment,
And
and they had something of attendance but no completion. So I know he represented that he did complete it. I just was not able to.
right, and I think,
Can I say something?
was this the one that we received that indicated that? Or was that another one? Was another one. Okay. I guess I don't have the proof of the treatment yet. myself, but
Last week when I was here, I gave my completion to Judge Reese, and I actually have my completion in my file.
you gave it to who?
Judge Reese, is that her name?
Well, we don't have a Judge Reese.
Oh. I gave her the copy last week and they made a copy of it. It's actually in my folder.
I was to say, that's from Bear River.
Yes.
The records I received today will be the most, I'll say, up to date records that was released this morning, Your Honor. And hopefully that is enough to, because it states on there.
Yes, they
successful
sent- Well, which records are you talking about?
They emailed it.
I actually have it. I see the verification of the discharge letter from Bear River. I see it now.
Okay.
Indicating that he has successfully completed the program.
Okay.
So I have it. I see it. It was one of the other papers that was on there. Okay. And that's the treatment you were talking
Correct.
about. Okay, very good. All right.
Your Honor.
You're welcome. So I will, the sentence of the court, $125 statutory fee. I'll order 90 days in jail, credit 61 that he served. The balance of that is suspended.
Thank you, Your Honor.
Okay, so I'm changing that. Good luck to you, sir.
Thank you, sir, and you have a wonderful day. Thank you. Thank you. Thank you. Oh, yes, I will, of course. I will not.
Court calls the case, People versus Wayne Rankin.
Carolyn Foster Tucker on behalf of Rankin. Can I state your name?
Your name?
Wayne Rankin.
All right. Go ahead.
And Your Honor, we have had a chance to review the pre-sentence report. We have no additions, corrections, or deletions. We would ask the court to follow the recommendation. Mr. Rankin did indicate that he needs a payment plan for the restitution and the fines and costs. He said he can make a payment by Friday
Yes.
of 200.
Yeah.
And then he believes he should be able to do $200 monthly payments. Is that right?
Yes, ma'am.
Anything you want to say, sir, before I impose that?
Just no, I don't really have much. I just take full accountability for my actions. Just made a bad error in judgment at the time. I just got back to working for a Bill property. I was laid off, so that's why I'm not being able to pay anything today.
Sentence of the court, $400 fines and costs, $3,484.87 restitution to the victim in this case payable through the court. I'll order 93 days suspended. As to the payment of the fines and costs and restitution, that's to be $200 per month beginning January 16, 2026. I will set a review hearing that will be June 10th, 2026 at 9 a.m. to verify compliance with the payment plan.
Okay.
All right.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Deanna Conrad.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Conrad. Ms. Conrad, state your name for the record, please. Deanna Conrad. Today is the date and time set for defendant today. Do ask that the court adopt the recommendation that Ms. Conrad has been in custody for quite some time. I would ask for a payment plan to be established with probation on the fines, so she can get out and get back on her feet before starting to pay those.
Anything you want to say, ma'am, before I impose sentence?
No,
And you know why you're here, right?
I do.
You gotta, He's got to do stuff different,
Yes.
right? The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient substance abuse treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court that you are placed on 12 months probation. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. That is to be paid in a payment plan as established by probation. There is to be no use of alcohol, recreational marijuana, or illegal substances. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's input panel attendance to probation. You're to attend 2 AA meetings per week with monthly verification to probation. You are to report to probation on January 20th. 2026 at 2 p.m. That is an in-person. Right? And then you're to report as directed. I'll order 93 days in jail, credit 47, balance is suspended. Right. Thank you.
Thank you, Your Honor.
Calls the case, People versus Rex Jenkins.
Incarcerated in a facility in Ohio. Your Honor, I do not believe he was writ for today's hearing, but I was able to meet with him and go over the recommendation, and he would be asking the court to follow it even without his presence.
All right. And so you're indicating that you wish the court to sentence him in absentia on this violation.
Yes, Your Honor, and I did speak with him directly yesterday, and he gave me permission to proceed in that manner.
All right. And so he admits to the violations of probation. In absentia, will sentence the defendant to 365 days in jail, credit 365 served. He is to pay $545 outstanding restitution balance that will be sent to our collections department. I will waive all remaining terms, discharge him from probation without approval. Thank you. Court calls the case, People versus Leo Stringa. Two cases.
Assistant Public Defender Natalie Pate, on behalf of Mr. Stringo, stands to my right. Please state your name for the record, sir.
Leo Stringer.
Thank you, Your Honor. Today's the date and time set for both cases. We have reviewed both the pre-sentence investigation reports and do not have any material corrections. And as to the recommendations for each case, we would respectfully request the court follow them.
Is there anything you want to say before the court imposes sentence?
Oh, yeah.
In the case ending in 1106, sends the court $125 statutory fee, $251.80 restitution to buyers payable through the court. That will be due 60 days after release. I will order 93 days in jail, credit 62 days. The balance the defendant is due. On the other matter, that ending in 0612, $125 statutory fee, $107.94 restitution to TJ Maxx payable through the court. That will also be due 60 days after release. And then I'll order 93 days jail, credit 62, the balance he is to serve. Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Eric Mays.
Assistant Public Defender Natalie Pate, with and on behalf of Mr. Mays, who stands to my right. Please state your name for the record, sir.
Eric Mays.
Teresa Claire on behalf of probation. Your Honor, Mr. Mays is before the court today for a violation of probation hearing. I know that the recommendation that I presented to the court today is a jail recommendation. However, I've had a chance to speak with counsel and Mr. Mays today. I would ask the court at this time, I would like to give Mr. Mays an opportunity to meet with me to provide what he has been doing. I think that treatment is a big component that Mr. Mays needs to accomplish. I would like to see where he is with that. Given that, I would ask the court to adjourn this violation hearing to February 25th, 2026, that Mr. Mays be placed on a scram tether today. My office could do the referral for that, have it sent over. And that he stay today and meet with me after I get out of court to go over and see what documentation. And I would also like Mr. Mays to know on the record that he is getting a very, very big break from me. So I expect that the court order to be followed. And then we'll see where things are at the February 25th BLP.
Thank you.
Thank you, Your Honor. That is all correct that Ms. Blair stated, and I would like to thank her for this, what's the word I'm looking for? Edited recommendation. I apologize, Your Honor. And Mr. Mays is also very grateful for the opportunity to get back into compliance with this. Obviously, we have absolutely no objection to the scram tether or anything like that. We would ask the court to adopt that recommendation.
Is there anything you want to say?
Just that I looking forward to, prove to the courts that I'm on my way to my rehabilitation, that I don't want to be able to talk to my family or my workers that I have that work for me to complete the jobs that we have going, and to show that I'm a good citizen of society.
All right, I'll go along with what probation is now recommending, but I'm going to let you know. Ms. Polera gives people a chance that's consistent with how this court feels. If you mess this up, I'm not going to be because the final decision is mine. I'm not going to at all be listening to any kind of break for it. You will just do time.
Sure.
Am I clear?
Perfectly clear.
I'll adjourn the violation of probation hearing to February 25th, 2026, 9 a.m. The defendant is ordered to meet with probation today, immediately following Ms. Blair's attendance in court today. The defendant is also going to be ordered to report to community corrections for placement on a scram tether today. All right. Okay. Thank you.
Thank you, Your Honor.
Put onto my office, that referral for the scram tether. You can go over and get it put on, and then I'll meet with you after.
Okay.
The court does call the case of People versus Legary and Thomas.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Thomas. Mr. Thomas, take your name for the record.
Legarian Thomas.
All right.
Your Honor, this is the show cause hearing for money owed. When I spoke with Ms. Thomas a few days ago, we were going to ask for an adjournment. Was in custody, he's out of custody, he's getting back on his feet. However, now that he's back in custody, he's obviously not working. So I just asked to set this out.
Well, I think what I'm going to do is I'll just refer this to collections, rather than bring it back and forth. So our collections department to deal with it.
Thank you, Your Honor. Mr. Thomas was asking what his bond is on this case, if the court has it.
Possible.
I believe it was a PR.
Right. Well, no. Posted 100. Now, his bond was denied. Then, yeah, so his bond was actually 10,000, 10% on April 30th. Then on September 22nd, 2025, the magistrate lowered it to 1,000, 10%, which he posted.
Okay, so he's not being held on this case then. All right.
Thank you, Your Honor.
Thank you. Court calls the case People versus Larry Evans.
Natalie Page, Mr. Evans. Your Honor, Mr. Evans has been actively texting me. He is on the bus and he was going to appear on Zoom today. He's been texting me since 8:30, trying to get on Zoom in about an hour.
He's on a bus?
He is. And
Where?
I look like, oh, literally just now, I'm in the building. Sorry. But 14 minutes ago.
So I can't issue a bench warrant?
No. Yeah, because.
He's in the building? Like where? Where?
I can go.
This is a big building.
It is. He's probably either about to go through security or just did. And I will say.
You're doing that Nebo look toward the door, hoping that he's gonna walk through at any moment.
I hope so, but I believe him. I will say this.
You do believe him?
Yes, Mr. Evans has never lied to me. He's talked to me a lot. So, never lied to me yet. This would be a weird first lie. Because I can so easily prove him
I don't
wrong.
think he's in the building.
I will text him. Hurry. Hurry.
Where? He's in the building. I'll pass it.
Thank you so much, Your Honor. I do appreciate it. Didn't meet yesterday too. We're prepared to see. But
Court calls the case People versus Carlos Mack. Say again. Oh, okay. Oh, there she is. Ms. Rushing?
Judge.
Good morning. Want to state your appearance?
Yes, Judge, can you hear me?
Yes, I can hear you.
Okay. Looks like I was having some connection issues. I apologize. Your Honor, Sydney Rushing, appearing on behalf of Mr. Mack this morning. And I'm standing in for his attorney of record, Mr. Byrd. Mr. Mack, is that okay with you?
Yes, ma'am.
All right, state your name.
Carlos Mack.
And can you state your name for the record? Oh,
We got that. I have here that an alcohol screening assessment was completed and defendant is currently being held with no bond because of his sober link violation.
that is correct, Your Honor. It's my understanding that to complete his assessment, he cannot do the portion that he has to complete yet in the custody. I believe that there is a request and agreement to allow him to be released on a scram tether so that assessment can take place and that his sentencing can proceed forward at the next date.
All right. Okay. I will allow the defendant to be released from custody with a scram tether that must be fitted on the defendant prior to release. Ms. Blair, were you going to do that referral or did you want to?
I can do it, Your Honor, if you'd like, or,
Ann already
Got
got it. All right. And that will be prior to release. Defendant is then referred to Von Schwartz for an alcohol screening and assessment. And the sentence in this case will be adjourned to February 11th, 2026 at 9 a.m. Thank you. Thank
Thank you so much, Judge. Happy New Year.
All right. Yes, and to you. My staff was just saying, what are we doing?
Thank you, Your Honor. At this time, my client is asking that a preliminary exam be set in this matter. Your Honor, we are asking for this to be set knowing that there is some outstanding evidence. My client has been in jail for 135 days, and we've asked for the DNA evidence multiple times. We just can't get the evidence. Your Honor, I'd also like to address bond when appropriate.
Okay. Well, I'll know, because every time we come up to DNA, and I'm not gonna ask when it's gonna be here, because who knows?
Which
So
I-
that won't be, the fact that if he wants an exam, he's gonna have it, but the fact that they don't have DNA is not gonna be the basis for an adjournment. You understand that, sir?
You understand that?
Yeah.
Mr. Johnson, thank you. Your Honor, when appropriate, I'd like to address bond.
Will the people have their witnesses available the 17th?
Do our best, Your Honor.
Preliminary examination, March 17th, 2026, 9 a.m. before Judge Moore. As to bond.
Your Honor, my client has currently been in for, I'm sorry, I misspoke, the line above. He's been in for 99 days. My client is very, very confident that the DNA on this particular item is not going to be his. He is asking if he could be tethered to his home. He's willing to do a GPS tether or even a home confinement tether. He does have medical needs that are not being addressed in the jail at this time. I have emailed about that, but there's certain, as the court is aware, there's things that they can do and cannot do. He has significant back pain and various other issues. Matter of fact, the day before this incident, he was at Trinity. Thank you, Your Honor, at Trinity before this. So we're just asking that he be released on tether, whichever type the court is inclined to allow. He still has his residency, and he's asking to be released.
Response to the people.
Your Honor, it's my understanding the defendant was on parole at the time of this incident. I'm assuming he has an NDOC holder bond is denied. I asked that bond continue.
Motion for bond reduction is denied. Bond will continue. March 17th before Judge Moore.
Thank you so much, Your Honor.
Thank you.
They do. Since I told you they don't tell. Maybe.
Court calls case People versus Jasmine Morris.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Naparilla, who is now approaching. Please state your name for the record.
Michael Naparilla.
I have before me a plea form that indicates that he's going to be pleading guilty to a added count 2, I think, of use of fentanyl. The 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. There's an agreement to no upfront jail.
That's correct, Your Honor.
All right. Let's have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give, the truth, the whole truth. Okay.
Sorry.
State your name, please.
Michael Naparilla.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Sir.
Understanding that you still wish to plead guilty?
Sir.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes,
Or
sir.
had one signed on your behalf?
Yes,
Is that correct? Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right. Are you on probation or parole?
I'm parole in Ohio.
Okay, at the time of this offense, were you on parole? Out of
Yes,
Ohio?
sir.
All right,
But they're aware of it.
okay. I do have to advise you that this could be considered a violation of your parole. If it is considered a violation, they could sentence you to the remaining portion of your term or send you back to do the remaining portion of your term or any other sanction in Ohio which would be available to them. You understand that, sir? All right. And understanding that you still wish to plead to this charge?
Yes, sir.
Anybody promise you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense? On May 25th, 2024, at the location of Gulfside Road, Pittsfield Township, Washington County, State of Michigan, did you have fentanyl in your possession? Did you use it? Did you know what you were using was fentanyl? All right. Sir, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea And the court would not be bound by any sentence evaluation or recommendation. You understand that, sir? Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
At 12 noon.
March 25th, 2026, noon, before me.
Your Honor, may I address bond when appropriate?
You may.
Your Honor, at this time, I'll be requesting a personal conscience bond. Mr. Naparua does have gainful employment. He does have a support system through his partner as well as his family. This case was just now reduced to a misdemeanor with agreement for no upfront jail time. He will be willing to go and test and comply with any of the court's orders. He would test clean, obviously, as he has been in custody for a short amount, for this amount of time. He does have, again, gainful employment, a car, a support system. He'll be willing.
Aren't they gonna take him back to Ohio?
No, my wife had talked to my parole agent. They're not worried about it just because since I went to jail in parole, they knew about this charge when I was released, so they're not basically worried about it.
And extra does show that the parole hold from Ohio was lifted. His parole agent did lift his holds, so he has no holds currently either.
I don't need a request from him. I'm gonna deny the request. I won't even consider release until such time as he's interviewed by my probation department.
Understood, Your Honor.
Then that should happen relatively quick. Thank you. Bond will continue. Court calls case People versus Michael Roseberg.
Judge,
Alexander, on behalf of the people, Your Honor.
Court shall cease to assistant public defender, on behalf. Please state your name for the record, sir.
Michael Eugene Roseberg.
Thank you.
Yes, sir.
Thank you, Judge. I did speak to my client. I believe he is requesting this matter I believe we're requesting this matter be set for preliminary examination. To my knowledge, all discovery is complete. And I believe Mr. Roseberg would like me to address bond when you're done.
Keep other witnesses available the 17th.
We'll try our best, Your Honor.
Preliminary examination in person, March 17th, 2026, 9 a.m. before Judge Moore. Pass the bond.
Thank you, Judge. He did meet with Mr. Niskar from our office this morning, and he did ask me to address his bond. He indicates that he is currently employed, fully employed as a night auditor / desk clerk for Quality Inn. He still has that job available to him right now. He'd like to make sure he keeps that job. He does have 4 children, 2 of which he supports via child support payments. He wants to make sure he doesn't get behind on those as well. Indicates he was last in trouble back in 2004 for a charge that has been resolved. He additionally indicates that he has his own place of residence right down the street here on Carpenter Road, and he would not have any contact with the alleged victim should the court release him. He would have no problem with a tethered home with work release, and he indicates he would appear for any and all court dates and follow any and all court orders. He'd expect either a PR bond or a $5,000 10% bond. He believes he can afford to post that if the court does grant a bond, Your Honor.
Your Honor, I'm going to object to this point. At the time of this offense, for the police court, Mr. Roseberg had a conditional bond out of favor of protecting the DP victims. There are 3 different victims. This occurred when they were out drinking with friends and while driving home. One person was driving and there were, I believe, 3 other women in this car. The defendant assaulted all of the people in the car by punching them. One of the victims had a buck on her forehead, a black eye, scratches to her arm and forehead. He also has holds out of Adrian for disorderly for $100 and Van Buren for $500 for assault. He has 3 convictions for breaking and entering, RNO, OWI, domestic violence, felonious assault, felony firearm, and larceny for courtesy, domestic violence, second. Those sending back to 2011 and beyond. At this point, I'm going to check these facts for completion.
I don't have anything further, Judge.
Motion for bond reduction is denied. Bond will continue.
Okay.
Thank you.
Thank you.
Thank you, Judge.
Thank you. Sharon?
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Sharon. Would you say your name, please, sir?
Thomas Sharon.
Okay, I have before me a plea form that indicates that he's gonna plead guilty to an added count 2 of entry without permission, a 90-day offense. Upon the successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement. Is that correct?
That is correct.
Yes, Your Honor.
They have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
State your name, please. State your name.
Thomas Sharon.
All right, Mr. Sharon, it's this court's understanding you're gonna plead guilty to the charge of entry without permission. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that, sir?
Yes, sir. Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that, sir?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed or had signed on your behalf an advice of rights form?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
On the date of February 18, 2024, Wise Hall at EMU in the city of Ypsilanti, Washtenaw County, state of Michigan, did you enter those premises?
Yes, sir.
Did you have permission to enter Wise Hall?
No, sir.
But it wasn't. Was it open to the public at the time?
Yes.
Or
I don't believe the hall is open to the public. It may not have been properly closed.
My understanding from watching the video, Judge, is that there's a security guard that you like get a badge in.
So
got it.
So I'm not sure.
So you did not have proper access, but entered the building anyway.
Yes.
And you knew you didn't have authority to enter the building.
Yes.
All right. Sir, if I accept your plea, if between the time that I accept your plea today and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would have to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
All right. Counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, thank you, Your Honor.
No.
And have I complied with the court rule?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be March 18, 2026, 10 a.m. before Judge Barr. Bond continued.
Your Honor, may we address bond?
You may.
Your Honor, Mr. Sharon has indicated that unlike at the time of the incident, which was, I believe, in 2024, he can stay with his sister who resides in Garden City. He says that he will return for all court dates. He will either be able to walk or take public transportation or have support from family. We are asking that the court consider a PR bond, especially given that the change in the charge.
Well, he didn't appear before, right?
Correct. That is correct.
Because he started out with a. So what you're saying, what changed from that?
He can reside with his sister.
So he has a more stable situation now.
Well, I would have where's this, what city?
Garden City? Garden City.
Well, I'm not gonna change his bond. I will leave it at that. Certainly you can address that with Judge Barr as to that, but with his history before me at this point, I'm not gonna change the bond. Okay. Thank you.
This courtroom sequence centers on sentencing decisions, probation compliance, and the court's emphasis on accountability balanced with rehabilitation. The primary legal theme is whether defendants demonstrate genuine effort toward reform or pose continued risk. The judge consistently weighs verified facts over assumptions, notably rejecting a bond violation after confirming treatment completion and identifying communication failures rather than misconduct. Across multiple cases, the court shows a pattern. Leniency is granted when supported by evidence of progress, but firm warnings accompany every second chance. Defendants who accepted responsibility and showed steps toward improvement received structured sentences, probation, or financial plans. In contrast, where risk factors remained, such as prior violence or unclear compliance, the court denied bond reductions without hesitation. Overall, the judge's approach is measured and consistent. Opportunity is given, but with clear boundaries. Compliance is expected, and failure carries immediate consequences.